out of 6 in our life cycle of an arbitration. We have now reached the stage of the evidentiary hearing, and we have 2 real heavyweights with us today who are going to talk you through what arbitrators expect from counsel during the evidentiary hearing. And I also want to extend a warm welcome to some of our guests who are joining us today. Several are participants in the CalArb writing competition, and we extended an invitation to allow them to continue joining the program while it's in session. And of course, we are going to make available the previous sessions that you may have missed, and anyone who isn't able to attend live can still view those. Without further ado, I'm going to turn it over to Eric Chang and Ruth Glick. Thank you for being with us today.
All right, thanks, Ghada. Good morning, good afternoon, good evening, depending on where you are. We've got a real treat for you guys today. Thanks for those new guests that are joining us. I want to introduce Ruth and then talk a little bit about what we are talking about today before I hand the reins over to her. So Ruth is one of our CalArb members. She is a full-time domestic and international arbitrator and mediator based in the Bay Area. Bay Area, is that correct? Yeah. Ruth has got several decades of experience. She's listed on a variety of institutional panels like the American Arbitration Association, the ICDR, the CPR. So she really brings a wealth of experience as both a mediator and arbitrator, which we're hoping to benefit from today. You can read her profile on the CalArb website if you would like to learn more. And we invited her today specifically for this topic. I'm going to be very, very biased, and I'm going to say this is the best topic of our series. Why? Because all of the topics that we've had up to this point, and I think that we will have, really kind of cover technical legal topics about the life cycle of the arbitration. Our discussion today is unique because it covers a much more qualitative but equally important topic of what arbitrators expect from counsel during an evidentiary hearing. So it's an equally important topic, if not more so. It's incredibly critical because it's not something that you're really likely to pick up or learn in any coursework. And it's not even really something that's articulated or kind of verbalized or really thought about in a separate or holistic way when you're working in a law firm setting as counsel. So it's just something that you kind of pick up through the years, if not decades of just repetition. And of course, unfortunately, hearings are far and few between. So today's talk is really meant to help short circuit that a bit and give you the benefit of Ruth's considerable experience from the viewpoint specifically of arbitrators. I will jump in and give a few points from the counsel's perspective as well. And we've distilled it into 6 broad points. And as always, we welcome questions. Don't be shy, speak up. Feel free to turn on your video if you'd like. You can use the raise hand function on Zoom if you'd like. All right, with that, I'm going to hand it over to Ruth. Ruth, welcome, and over to you.
Thank you, Eric, and good morning from Northern California. To the rest of you who I cannot see, I don't know, everyone is, I'm looking at names, and I just want to start out by saying when you're in arbitration, it's a person-to-person business, and I would say you want to connect with the arbitrator, but how can I connect with you when I don't see you? So if anybody is dressed and wants to put on their video, that would be great.
Only if you're dressed.
So, and then I was going to ask you all if any of you have served as the counsel in an arbitration before, or served as a secretary to a tribunal. So, good morning. I see some of you now. Whether you have any experience to share, but I'll just say generally, we as arbitrators come to this with an open, independent, and impartial mind. And we want to understand the case. We want to do our best to provide a fair decision, fair rendering of what our thoughts are. So in the beginning, as I say, we're a person to person process. And so we expect, to meet you either in person or by Zoom, but certainly if we were by Zoom and if you were appearing before me, I would expect to see your video. I know you're not appearing before me this morning, but I just thought I would make that point because we expect a certain amount of professionalism and civility and cooperation between the attorneys and with, of course, the arbitrator who you is the most important person in the room, or the tribunal if they're 3 or 5. It's because we know nothing about your case, and we are going to be impressed by your professionalism and your ability to navigate it through the arbitration process. I wanted to talk a little bit about the cooperation part. In the beginning, we put together a scheduling order, which we normally would first ask the parties to meet and confer, at least talk about potential dates for the arbitration. Earlier, we were saying Eric has a 4-year-old arbitration, which he's advocating in. I say I try to keep everybody within a year, but that's get increasingly impossible. But I try to deliver on the beauty of arbitration, which is that it's cost effective, and it is a process in which you have the full attention of an arbitrator or a tribunal to resolve the dispute in a cost-effective way for your clients. So I asked the parties to meet and confer about potential dates and issues that may come up, whether they're going to be motions or what. And then I have them either provide that information to me. I may provide them with a bit of a questionnaire first. And that's all before the what I call the pre-hearing scheduling meeting. Pre-hearing scheduling meeting these days is mostly on Zoom or some sort of teleconference. And at that point, at least I know they've met and conferred. They have demonstrated their professionalism by trying to cooperate with each other on some of these strictly maybe procedural things. And even they don't have to agree. Obviously, they're in arbitration, but they'll agree that I'm going, one party is going to bring a motion or whatever. And then what we can do in the scheduling hearing is that we can put that on the calendar for, submissions. And I expect them also in my scheduling order. I usually say that the parties will meet and confer regarding any discovery issues that they have. And if they cannot resolve them, then they will notify me and I will come in and we'll probably have a Zoom hearing and I'll resolve them for you when you can't resolve them yourselves. So I would say just basically on this first point, Eric, as an arbitrator, this is the first time I'm seeing the parties. I'm hearing from their counsel. I'm getting a sense of their professionalism, their ability to meet and confer with the opposing side, their ability to express the issues of the case. We're not going to go into yet the storytelling of the case, but just the procedural issues of the case, so we get it on the calendar. And I'm going to throw it back to you, Eric. You've done so much as a counsel. What is it that you expect of the arbitrator at this point?
Yeah, I mean, I think the parties and counsel for the parties do expect arbitrators to helm the dispute and be decisive. That being said, as you mentioned, civility, cooperation is kind of key. I don't get a sense that arbitrators, once that the meet and confer, like once the sort of roadmap is set, to a large degree, it is the parties that kind of drive the process, right? It's a adversarial process for the most part. And so that's where sort of the civility, the cooperation happens. It doesn't have to be, you know, I think arbitration used to be possibly more collegial than it is today. It's becoming, unfortunately, more and more like litigation. It's very, very hard fought, but there's kind of an underlying, basic floor of civility, and just cooperation between the counsel. So, every time um, you can't bring every spat to the arbitrators. They absolutely hate that, and they expect, big boy pants, put your big boy pants on, and just sort out the issues to the degree possible between you before you start bringing them to the arbitrator. And I would say, that it's unavoidable, right? You're always going to have something where you're like, no, this is, I need to raise this issue with the tribunal, and my advice is keep your powder dry and, pick and choose your battles very carefully, right? Save the big stuff, save the communications with the tribunal for the big stuff. And it kind of maintains this cooperation, and it keeps the tribunal happy. And ultimately, as counsel, that's what you want to do. You want to keep the arbitrators happy, kind of keep them on your side and keep moving things along.
Yeah. So let's say we get through the first scheduling hearing. I would say even at the hearing, I just want you all to understand, when I get a case, and I've worked through American Arbitration, ICDR, I only can access what's on their e-center. So I can only access, what the claim is and what the response is. And normally the response doesn't tell you much. So I don't know very much about the case. Think of me as a blank sheet of paper, although I'm not, but think of me and as that. And so your first opportunity to see me is at this scheduling hearing. And so just a one or two sentences about what this case is about is already telling me this is a breach of contract case and a distributorship, or this is whatever it is, EB5 case, or whatever's in store for me. I want to understand that, and I'm always, now that piques my interest. What went wrong? Why is this case in dispute? And I want that from both the claimant and the respondent's side, to give sort of a little bit of a brief overall picture. Everyone seems to forget to do that, but once we get beyond that and we get into discovery, I still need to know more about the details of the dispute before I can determine whether the discovery is relevant, proportional, etc., to the dispute. So always a good, just remember, whatever is on file and the e-center is all I know. So if I might ask in the scheduling conference to write a more detailed or specific set of claims and responses, just so that I have a better idea. I need to know what it's about. And I need you to tell me the story, because, as you said, I'm the blank sheet of paper here. You need to tell me it from your client's point of view. You need to tell me your strongest arguments, and you need to tell me the facts that are relevant. You need to tell me the time frame that's relevant. You need to just, in a sense, just give me a strong opening brief that tells me a story. Eric, you agree with that from your point
I
of view?
do. I'll answer your question with another question. How important to you as an arbitrator or actually, let's stick to arbitrator. How important to you as an arbitrator are the equities in the case? How
Well,
much does that influence, the equities, who you think is the proverbial good guy and the proverbial bad guy in this? Like, how does that affect your thinking as an arbitrator
in the beginning,
without revealing any secret sauce?
Yeah. No, in the beginning, I don't even think of the equities. I'm gathering the facts, and I try very much not to be influenced. I'm always conscious of any biases, unconscious or not, that I may have. And so I really train myself not to. Maybe at the end of the case, in specific instances, it might weigh in terms of influencing you, but I judge things by the facts and the law and, its application, the application of the facts to the law. Uh,
Okay.
how,
Yeah, it's
how about you
interesting.
when you're an arbitrator?
Well, I've had a handful of cases. I mean, I'm not, I think that arbitrators are human beings, right? We're human beings. We are, as much as we try to um, call the strikes and the balls, as the Supreme Court Chief Justice said. I think it is, disputes are a human endeavor, right? And I'll tell you from my counsel's point of view. We are constantly trying to put together not only the facts, present the facts and the law at the evidentiary hearing in an opening presentation to the tribunal, but I think it is absolutely key to frame everything in a strong narrative. A strong narrative is a really powerful tool to get the equities in your client's favor. And even though as Ruth said, as an arbitrator, they're trying to keep it as impartial, neutral, and just sort of just the facts, right? They're just trying to get the facts. Um, it's again, it's an advocacy. We are advocates on the counsel side, right? So we are trying to display the equities. Good advocacy means that you are a storyteller as much as you are a lawyer. It is, I would say, as important. It's that important, right? It is as important as the law and the facts, is to really kind of frame everything in a story and in a narrative that you can present to a theory of the case, right? That you can present to the tribunal. And I'll even take a step back. Ruth, you said something really interesting. Is when you start out, you don't know anything. I think that as counsel, we present ourselves. We are extensions of the client, where we are extensions of the party, and how we present ourselves and how we convey ourselves, how we communicate our image to the tribunal is equally really, really important, because it reflects on the client. Again, it's a human. It's human psychology, and I would say that to the extent that this entire endeavor, arbitration, is such a small community. Your reputation is everything. It may well be that the arbitrators know you, at least by reputation beforehand, or maybe know you professionally because you have met in conferences, or they have worked with somebody who happens to know you, and it's inevitable. They'll be like, "Hey, I've got so and so in a case, what are they like?" Right? It's a very small community, so it's super important to do things like attend conferences. These conferences. We're in a weird world where the arbitrators are pulled from the community of counsel largely, right? So when you go to these conferences, as you kind of get more and more senior, you attend these conferences, you're meeting the people that you will be nominating as arbitrators. The adverse party is going to nominate as their arbitrators, and then they're going to nominate as the chairperson. So it's super important to get out there, build a strong reputation, so that by the time you're at that hearing, you're already coming in with, I think, making a favorable impression on the tribunal, which I think rubs off to some degree on your client.
So let me just follow up with something. A good counsel can make up so much for a bad client. Because, I don't know your
So
client.
please, everybody take notes, because that was a super important.
But if you present it and you're likable, you have to be likable. Again, it's a human to human process. and you're presenting everything very professionally and with a great deal of confidence. You know, the arbitrators want to begin to trust you for presenting the true facts of the case. So it's all a process, but I really think that the likability of the counsel is an important aspect that we seem to forget about. You can make yourself likable.
That's a great piece of advice.
So should we go on to the hearing?
Yep, that's good timing.
Okay, so we're at the hearing, and hopefully you've educated me somewhat about your case, but now it's the chance for you to really present that evidence that I'm going to either find reliable or not. And so this is an opportunity to show your organization skills and your deep knowledge of all the facts of the case. It's an opportunity for you to provide sort of a roadmap, first of all, in the opening statement. I want to have a roadmap of what you're going to prove. And I want you to follow it, obviously. I always, and the other thing that I always do, which counsel never seems to give me, is somehow, let's say it's a breach of contract case or something. I need a chronology. When did the alleged breach happen, or what happened before or after? Because I will reconstruct that, but you can save me time and you can show it to the advantage of your client. And I think also in your opening, you might discuss what you think your opponent's biggest argument is and why it doesn't wash, without getting too adversarial. I just want to hear it from your point of view. I want to hear it from the opponent's point of view. And then I'm going to be looking for the evidence that proves one or the other. Or sometimes it proves, sometimes it's hard if one doesn't know what the evidence is going to prove. Um, um, but I want that evidence to be relevant, and I want sort of a strategy that you're following, and who you're calling at what time, who you're calling to give the evidence. Are you going to be using witness statements? Are you going to be using experts? I want to know what the procedure from how you are presenting the case that shows your confidence in your client and in your case, and that works for both sides, or more than two sides if it's a complicated case. Eric, I'm sure you do that all the time.
Yes, I'm about to do that in a short few weeks. I mean, I 100% agree. I think the opening statement is very often the first, especially now, sort of in the post-COVID world, but even before then, it usually is the first time that you are physically in front of the tribunal. So again, reputation matters, your presentation style matters, likability matters, but this is your first chance to make an impactful statement in front of the tribunal. And I think that one of the most important things, going to what you're saying, Ruth, is to provide, I mean, from the counsel's perspective, is to provide a streamlined opening statement. In especially larger cases, you start to get really bogged down in the details. I mean, the case I'm in right now, we filed a 420-page brief, and then they just filed a 340 or 60-page brief. It's massive, right? I mean, it's hundreds and hundreds of exhibits. This is, what arbitrators are paid to do, right? They are very detailed. They are extremely detail oriented, but at the same time, it's really incumbent upon the counsel to to distill everything into the key points at the opening statement. So think about that narrative, right? Think about the narrative. Think about presenting the equities, and I would say don't get bogged down in the minute details. And I think the most important one of the most important lessons I've learned over the years is, as you start getting towards the end of the hearing, or the end of the case, the hearing and maybe the post-hearing briefs, if there are any, is you're starting to get to a phase where the tribunal's starting to, okay, they're going to be deciding the case very soon. Give the tribunal, give the arbitrator a path to a favorable decision. Okay, that it's worth repeating. Give the tribunal a path to a decision. Think about, like, how am I presenting this so that the arbitrator, Ruth, can say, okay, yeah, I've been given a solution that I can just pick up. This looks right to me. I'm going to be able to take it and go with it, right? Because I think that the claimant or the respondent is correct on this. So it's really, distilling everything down to its essence, not pushing out the noise, not getting bogged down by the details, streamlining everything, presenting that, streamlined chronology of the facts or the story, and then really starting to give the arbitrator a path to a solution that's favorable for your client.
Yeah, we like to think we find our own path, but no,
Again, the
I
advocacy
appreciate that. But
the advocacy piece matters, right? If I think if it gets bogged, what I'm saying is that very often we get bogged down in the details, and there's so much noise that I think we're not giving the tribunal sort of a clear sort of, here's what we want you to decide. I mean, it gets so lost in the sauce sometimes that I think both sides, just get bogged down in the details, and the tribunal is kind of left with this giant undigested mass, right? And it's our jobs as advocate to distill that into a very precise message for the tribunal.
well, I mean, your 400-page briefs are would actually require a path. I've had some large and complex cases with, lots of orders and lots of paper, now electronic. I think a path is I think that's good advice, but it also needs to tell me the your opponent's best arguments, why they don't hold. You have to have an explanation for everything, because otherwise I'm going to look for it and maybe not find it. So, and sometimes it's hard. Sometimes the facts are not in your favor, and we don't want you to make things up, and not, what's our expression? We don't necessarily want you to paint lipstick on a pig or something. But there are ways in which you can rationally uh, perhaps show how that piece of evidence should not necessarily be determinative. Um, it's all an art, as as a advocate in these international cases. It's an art. It's an art also when you're dealing with different cultures, different, civil versus common law. It's an art, and make sure, I think it's important for everyone to be on the same page and understand. And it it's fine to sometimes give an explanation. You're not talking down to the arbitrator if you do it in just the right kind of tone of voice, and as it applies to something. Um, we're listening to everything. I think that during the hearing, we want you to be organized and efficient. So just think of large and complex cases where you got, just the room is filled with binders, and arbitrators will look on our computer. Sometimes it's easier. I always like to have a joint exhibit binder, so one main binder on my desk that I can refer to, like to the contract, or something, the pieces of evidence that are not in dispute, or even some that are. Um, but I need you to be organized, and I've seen account, and Eric, you can comment on how counsel gets themselves organized, but I've seen them where they have a separate binder for either direct or cross of certain witnesses. I've seen, how they've organized themselves so everything is easily at hand. Um, I think that you want to be prepared for each witness for each fact. And I think also one thing that you should look to maybe at the end of witness testimony, arbitrators usually do not like to interrupt with questions unless it's something we didn't hear, or what was that date, or could you, something like that. But afterwards, the arbitrators will ask questions after you have, direct and cross and recross. Listen to those questions carefully. It's either something we didn't quite understand in your presentation. It's something we might be more interested in exploring. I mean, obviously you must respond to it, but I think you should always, good counsel I've seen have always listened to those questions, and later on in the case say, oh, well, when arbitrator so-and-so said that, this is how we apply it here, or something like that. So just really, um, it gives you a little bit of a clue of what we either want to have some clarification for, or some further interest in exploring. Eric, I'm sure you respond right away and keep note of that.
I do. I try to. I think it's, yeah, I mean, one of the things I don't like about Zoom is that it is harder to read body language. And I think that tribunals, again, are human. And when folks are talking in a hearing room, or witness testimonies or expert testimonies happening, I'm kind of, I've got one eye that's focused on whoever's testifying, and I've got another eye on the tribunal's reaction. And I think even beyond, tribunals asking questions was absolutely, are, their keys to, their little kind of like little windows into the tribunal's thinking. I think body language is really important in that sense as well. And so it's really important to kind of always being, paying attention to what the tribunal is doing. I mean, I've seen counsel, speechifying, right, just rattling on, and I'm kind of looking over at the tribunal, and they're just catatonic, right? It's or they're saying something, and I can see them like, frowning and kind of shaking their head and flipping through some pages, and I'm actively taking notes. They're like, okay, they've picked up something that opposing counsel has said that they're not happy with, and I'm gonna make sure I note that, so that when it's my turn to speak, I go in and I exploit that weakness of whatever, I think is going on. But organization and efficiency, Ruth, is super important, I think, in general. Sweating the details is part of, I think, the reputation thing I was talking about. It's part of reflecting well on the client and on the case. I mean, strong advocacy is not just, telling that narrative that I was talking about. It's really having a robust grasp of the details of the case, even on
Yeah.
smaller cases. It's just, from the issues to the exhibits, being able to have a mastery of stuff, so you're not constantly like, just flustered. And, there's nothing worse than being disorganized and not prepared at the hearing. And it's happened to me. I think it happens to everybody at some point, and it's just the worst feeling in the world. And I think it just does not reflect well on you personally as counsel, or me personally as counsel, or on the case, or on the client, right? I'll just say, Ruth, that you'd mentioned, how large cases are organized. In a lot of cases nowadays, the tribunals will themselves issue procedural orders, where they're very particular about how they want stuff to be organized. And it is really important to pay attention to that and actually do it. And I myself go back, the terms of reference and the early procedural orders, or any procedural orders really, I find that I'm constantly referring back, because a lot of times they've already told you how they want stuff done, right? Like they've already said on evidence, this is how I want it. Like, we want a joint set of binders, or we want this format, we want that. And I've seen it, where the tribunal the one or both of the parties don't do what the tribunals ask for, and and they get exasperated because they're like, look, man, I've already asked you for that. So it's really important to pay attention to what they've already said, usually in a terms of reference or procedural order, or maybe even via email. But it's, again, like, efficiency is it's a floor, right? You're not going to win a case on efficiency, but you can certainly, lose a case or put your case in jeopardy if you're not efficient, if you don't have a robust grasp of the details at the hearing.
Yeah. So good points. I just wanted to, and particularly the terms of reference and the orders that the arbitrators give, we assume you will follow our orders, and you better. But again, during the hearing, you as an advocate are busy putting on your case. Your mind is active. We're sitting here, the panel, the tribunal is sitting, taking notes, sometimes multitasking because we may have to rule on some objections. But we also, you can lull us into sleep if you keep beating a dead horse. And often we will say, this has been asked and answered, let's move on. Remember, I mean, you may have the best point in the world and, obviously make sure everybody understands it. But sometimes maybe advocates themselves get tired and they're going over the same thing, and that you're putting your panel to sleep, you're putting the tribunal to sleep. So remember to make your points and move on. And also, just look at the panel, the members, and see, are they attentive? Are they, where are their eyes closed? I don't think many of them do close their eyes, but you can tell a lot, as Eric said, by body language. Which you can still do that on Zoom, but I mean, when you're in a hearing room together, I think it's good too to also, obviously you don't want to take too many breaks, but people need to get up and stretch and walk and just get the juices going, because you can't, you want everyone to be their most attentive self. And so I think you have to keep the energy going in the hearing room. You do that by being organized, and then we're in.
Ruth, can I add a point? Yeah. Ruth, let me add a point real quick about, again, this idea of organization and efficiency. This is super important as in your junior years, because in a lot of cases you will be supporting a senior advocate, right? So a senior partner or senior whoever, who's going to be kind of doing, a lot of the key direct and cross-examination, is going to be giving the presentation, and he or she's going to have a ton of things to deal with, and it's super important as the junior. I think in my earlier years, if I'm very honest, I think I was too passive in these things. I was kind of absorbing everything, but not really thinking about, like, what is my role to support the senior partner on this. And a large part of that boils down to being organized and efficient. You are the person who's got the mastery of all of the exhibits, who's got all the procedural orders in mind, who's got, everything sort of at your fingertips, so that, you're listening to what your partner is saying, and you're anticipating their needs, because you're really kind of supporting. As you get more senior, as you're, getting into a mid-level senior associate, maybe even junior partner role, that the task changes a little bit, and it's still efficiency and organization, but in a more strategic way, right? So it might be going to, Ruth's point, it's kind of passing a note along and saying, like, let's move on, or, they got the point, or, hit this point more, whispering to them or handing them a note or whatever, right? Again, in a supporting role, but being an extra brain for the senior partner. And then, of course, when you're the senior partner, then you're kind of the tip of the spear. But it is very much a team presenting at a hearings is it's almost military style, right? It's very hierarchical, and everybody's got a very defined sort of a function and role that is in support of the case. And so when you're thinking about organization and efficiency, just realize that it means different things at different stages of your career.
Yeah, I think that's good points. I've seen, junior co-counsel really be helpful to the senior first chair by digging up evidence to impeach or pointing things
Yes.
out, because one
Yeah.
person can't do it all.
Yeah.
By keeping his or her eye on the tribunal, what are they doing? Are they involved and attentive, etc.? So it's a very important role. You don't just sit and listen, you're active, you're thinking ahead, you're thinking, how can you help your co-counsel bring it
I
home?
wanted to jump in there because that's, I think, a super valid point, and maybe ask Ruth, are you seeing in cases where the senior partner is actually making space for a junior person on their team to present a certain part of the case in terms of maybe being in charge of examining a witness, or actually being able to use their advocacy skills in another way?
Yes, I do see typically that junior partner may get to take one witness and present that. Depending on how junior they are or how good they are, they might get a couple. But yeah, I see them somewhat involved as their skill demonstrates, I believe, and I would think that in these big cases, the senior counsel would want that assistance. They needed a little time off to rest their brain and have give that experience to somebody.
I'll jump on that and say that, there was a movement some years back to push the sort of arbitration community for law firms and senior partners to think about giving more advocacy roles to junior lawyers. And in fact, that followed efforts at at various litigation bars in various countries. I think it happened in the US in some states, and then in the UK as well. And I've actually seen tribunals say at the outset, like, I would love to hear, I would love to see some advocacy from the junior lawyers. And they say that at the pre-hearing conference well in advance so that there's time. And so my advice to junior lawyers is to not be shy and say, like, and just ask. I'd love to take on a witness, one of the peripheral witnesses. Quite honestly, right now I'm in a case where we've got, I think when all is said and done, we'll have 40 experts and witnesses all combined on both sides. It's an enormous task, and quite frankly, we're happy to offload some stuff. We don't have a choice, actually, right? But to the extent that you can, ask for it and say, like, hey, here's a witness. It's not a key witness, but it's still somebody important that we're going to want to do a direct on or do a cross on, and ask for the opportunity to do it. And I think that tribunals are, Ruth, please, let me know what you think of this. But I think tribunals will give some leeway to young advocates who come in and it's their first role. I know I felt like when I first started getting speaking roles, I was, they still ask tough questions, and still, they still kind of, the tribunal still handle the matter professionally, but I got a little bit of the kid gloves treatment, I have to say. But I think that's how you learn, and I think that tribunals are generally receptive to it. What do you think?
Yes, I was going to say most of the arbitrators tend to be a bit older, and when they say a new, young, energetic counsel, we pay extra attention. We want to see you succeed. But let me go back, Eric. You mentioned you have 40 witnesses. What
And
are
experts, yeah.
you using witness statements, and what's the advantage of using that, and what's your experience?
Yeah, we do. So in these types of cases, typically witness statements have gone in with the briefs, right? With each round of briefs, statement of claim, statement of defense, statement of reply, statement of the rejoinder, et cetera. And at each stage, the witnesses have put in statements, so that by the time you get to the hearings, the factual issues have sort of crystallized, right? Like what my witness says XYZ and their witnesses, well, no, it actually was 1, 2, 3. By the time that we get to the hearings, the facts have kind of crystallized, and the tribunal can really quickly hone in on, what are the issues, what does everybody kind of agree on as a factual floor, and like what is really at issue here with these witnesses. So that's usually how we proceed, which I think is good in terms of there's no surprises left, really. I mean, there still are, but largely there's no sort of huge gotcha moments for the most part. But at the same time, it creates an enormous amount of paperwork, right? And it creates a lot of a lot of paper for the tribunal to digest. And again, it's the counsel's job as advocates to kind of like distill that into, look, here's what really matters. Dear tribunal, here's what really matters, right? Forget all this noise here. This is what's at issue.
Mm-hmm.
Yeah. And I was going to say, how do you hone your cross-examination skills when using a witness a statement which you've already absorbed, but now the witness is on the stand, so to speak? Is this a way for you to be much more efficient and hone right in, as you were speaking earlier?
Yeah, that's another really great point, Ruth. I think again, as a more junior lawyer, there are great opportunities to take the workload off of the senior lawyer and to say, I will prepare you the cross-examination, right? And that's a great way to get experience, even if you don't have a speaking role just yet, right? Because you're practicing, right? And then you pay attention at the hearing, like how did that go, right? Or of course, the senior lawyer will look at the cross-exam questions and then edit them or prepare them, and pay attention to like what your work product looked like and what they ended up doing with it, and then like how did it actually go down at the hearing. So there's a lot of, I think, opportunities to learn even before you ever have a speaking role at a hearing as a junior lawyer. Typically, the way that we were taught was with cross-examinations, you don't, always ask sort of, yes, no questions, never ask a question you don't know the answer to, right? And you kind of start with, you reverse engineer. The best advice I ever got was to reverse engineer a series of statements that you would like the opposing side's witness to say. I would love it if they conceded 1, 2, 3, 4, 5, and then work backwards. Ask questions that build up to them arriving at that statement. And that's sort of generally the way we did it. I mean, obviously with variations, or there's different approaches, but my main point is that there's great opportunities to get experience in cross-examination before you're actually doing the cross-examination. And again, like as the main lawyer, depending on how the hearing room is set up, if you're sitting next to a senior lawyer who's doing the cross, you're not just sitting there passively as a junior lawyer. I would be sort of furiously flipping through, exhibits and stuff and kind of thinking. And then if there's a point, that maybe the senior lawyer missed, or maybe there's a direct, exhibit that directly contradicts what the person said, I'll be feeding that stuff, by the shovelful to the senior lawyer. Again, I'm just an extra brain that, extra sort of brain power to help the senior lawyer make an effective cross-examination. So there's a lot of different touch points where you can have an impact or have experience on cross-examination, even before you are the lead sort of cross-examiner, so to speak.
Yeah. I was going to say, as an arbitrator, we love it when you get right to the point. as you mentioned, leading up to it, because we have already read those witness statements. We may have questions, but when you demonstrate it through effective cross-examination skills, it's very effective for us to understand the case better. I think also those of us who were born and raised in America and watch TV and see all, the Perry Mason and I don't know, they're more current examples of lawyers on television doing very dramatic, cross-examinations. Well, it doesn't quite always happen in arbitration, and certainly it is not expected in the international arbitration. It's far less dramatic and showy than what some of us think the arbitration should be.
Yeah. That's such an interesting. Let me ask you a question, Ruth. I mean, there's always a tension as counsel between, sort of an effective, impactful, direct or cross-examination. Let's just stick to cross-examination, right? To make an impactful cross-examination on the spot at the hearing and kind of, keeping an eye on the tribunal and said, yeah, I definitely scored a point here, right? There's a tension between that and also kind of building a record, right? So a lot of these cases have transcripts, and you're also, I also cross-examine with a view to building a record in the transcript that I can then kind of in a post-hearing brief feedback. It's a very different sort of, and they're very different tasks in a way, and the how you cross-examine is different depending on how, whether you want to be impactful on the spot or maybe, it seems like you're droning on, but, when you read the transcripts always read different than how it went down in the actual hearing room, right? And then you can, if you have a post-hearing brief, you could pick really impactful Q&As, build your case that way. How do you see that? Like, where do you see the tension? For you as an arbitrator, are you kind of more interested in one or the other, or it depends?
Well, I think you can do both. You make your impactful question and answer. You might look at the panel. You're like, you don't have to say anything, just look at them, see, and then you might repeat it again so it's clear in the record.
Right.
And I think those kind of it's just sort of the style, I think, of counsel, but they know how to make the point.
Yeah. I think that's a good point, is kind of emphasizing, when something important's been said and kind of looking over to the tribunal
Yes.
and
Yeah.
going like this. No.
No, but I mean, you don't want to.
So
But
Ruth, we have
it's not as dramatic as Lincoln Lawyer or some
right.
other things that I'm watching on TV. But let's get to the close.
Yep.
I think is important because remember, we said at the start of the arbitration, you want to give the arbitrators a roadmap. What is it? What is the case about, and what are you going to prove? The close is your opportunity to say, this is what the case is about, and this is what I proved, and this is why my client should prevail. And I think you need to provide not only the facts, but the law. And, many of us in the tribunals ask that when you send a closing brief, for example, that it hyperlinks to the case, or you send us a zip file so we can easily access the case. We're going to look at those cases, and now with AI, I haven't used it yet, but I understand you can, easily connect it. It can find it for you, and we'll double check to make sure everything is reliable. But we want you to wrap the package up for us. How does the facts, the theory, and how does the law substantiate what you're trying to prove? And I think there are many ways to do that. You've got to be effective. You've had to have someone taking notes, and maybe as a junior lawyer, that's your job to take those notes. And for your job to maybe put it into a form that's going to be effective for your co-counsel or senior counsel to bring it home to the tribunal.
Yeah. And again, kind of looking at it from a junior lawyer's point of view, with these hearings, you've got, especially with larger hearings, you've got 3 days, 4 days, 5 days, sometimes 2 weeks of hearings. And at the end of it, there's no break, right? Like you finish up the last witness, tribunal's asking questions, they kind of wrap it up, and then they say, okay, tomorrow morning we'll hear closing arguments. And then you've got like kind of a sleepless night putting it all together. And as a junior lawyer, you're really trying to help the senior partner, whoever, package all that up, right? So throughout the hearings, you're already starting to gather information, right? Little bits and bobs of the transcript or exhibits, key exhibits, and so that you can package it all up for the senior partner to then make a super effective, very impactful close the next day. And, they're usually pretty miserable because there's no time. There's no, you're spending a sleepless night. It's like, yeah, you're not really sleeping the night before, as my experience, because there's so much. You've got like a week's worth of testimony and exhibits and this and that, and then you're trying to digest all that and give it to the senior partner to then present it. For the senior partner, there's different ways to do it, but one effective way of closing is to say, again, keeping it very streamlined and keeping in mind that we're now at the decision point, right? The tribunal is going to make a decision, so really kind of focusing on the last really important points. And one sort of effective rhetorical tool is to say, look, at the beginning of the hearings, at the opening statements, I promised you, tribunal, I promised you that I would prove this, this, and this, and that the law says this, this, and this, right? Whatever. And then at the close, to say, a week ago, I told you that I would do this, this, and this, and this, this, and that. And this week's worth of hearing have absolutely, I've delivered on that, right? Because of X, Y, and Z, 1, 2, and 3. So kind of like bringing them back and saying like, I promised you this, and this entire week's worth of expert testimony and witness testimony has absolutely supported, corroborated, proved, confirmed that. There's different rhetorical devices that you can use. Whatever you do use at the end, I think it's you're as Ruth, as you said, you're kind of like wrapping it up, right? Again, not getting lost in the details, shutting out all the noise, because there's going to be 1,000,001 different like ancillary points, right? What is this case really about? If it's a breach of contract, right? Like focus in on the core breach or the non-breach, whatever the case may be. So kind of wrapping it up in a nice bow tie, presenting them. And again, as much as possible, presenting a pathway to the tribunal, right? If we've proved this and this and this, and if you tribunal, if you believe that this happened and this happened and this happened, then you must conclude that a breach of contract happened or whatever the case is about, right? And to really kind of push them towards hopefully the decision that is favorable for your client.
I was going to add that what we as arbitrators do when we're finally gathering all the information and organizing ourselves to write the award is we go back to the original claim. The original claim, not even, I mean, obviously the opening brief and the closing brief. We want to make sure that we address every claim that's asserted, and we want to and that's one thing, when you're writing your closing brief, I think if you refer to each one and how you think you prevailed, that's a great help for yourself and for the arbitrators. So remember that. And also gosh, there's so much going on now with artificial intelligence and how do arbitrators think and all that, but it's really simple. We amass the information. I think we are we're open, and we want to organize, and we want to again look at the facts and see what was proven or disproven, what's relevant or what isn't, what we were writing a reasoned award, and so we have to really spell out our reasoning on why we believe something, and that helps us in making that determination, which we hope to be fair and equitable.
Well, Ruth, that was the perfect segue to our next session, which will be focused on award writing. And today we're actually at time. Thank you both for this really in-depth, I think it really gave and set the tone and the picture for how junior lawyers can really be as effective as possible in the evidentiary hearing and to see where your role is in building all those skills. So I want to thank you both again, and for everyone who attended. We're going to go ahead and adjourn for today and see you back in 2 weeks for our final session on awards. Thank you so much, Ruth and Eric.
Thank you.
Thanks, Ghada, and thank you, David.
Thank you.